Ladies and gentlemen, gentlemen and ladies, we have George Benson in our background and he's talking about a ghetto of a world. Okay? And I guess the world is a ghetto. I just did a video talking about this document right here. The video talks about this document. I won't have this document. I decided I'm going to finish this document. I won't have it complete for you until, pay attention, until a couple of weeks. Sorry, but I just don't have the time. There is something that I am going to do right now, and we're going to put here OTICE. Okay, just that simple. That's going to be at the top, because the first thing before you do anything else, the first thing you must do is you must challenge the court's jurisdiction. So you'll challenge the court's jurisdiction without saying, hey, look here, mother, I challenge your jurisdiction. Okay? By the way, you definitely won't be putting your phone number in this thing. So I will take care of this. I will get something completed for you guys. I will make it general so it's not just California, it's every state. Okay? Technically, I can do a general motion. I'll probably take it off of this page and get rid of these lines. Hold on. Because this is, when they did this, they used, uh-oh, I messed up. I almost had it. Nope, gotta undo that. The world is a ghetto, y'all. So, let's show y'all. Hold on. Dang it. There we go. Now, let's see if it'll let me. Alright. The only thing is, I can't have this going. I need this, so I don't feel like typing it again, y'all. You know what I'm saying, dude? I just don't feel like typing it again. Okay? Let's go from there to here. Oh, so you want me to... There we go. Copy. Now let's get rid of all that junk. And we're going to just go cut. There you go. And now... Oh, God, no. Wasn't supposed to do that. I got to undo that. Okay, let me do this like this. There's an easier way. Wait a minute. There's a much easier way. Watch this. Cut. Wait, hold on. Cut. 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 All right. Let's do it this way. Nope, it did it again. All right, so that ain't the easier way. Okay. I just got to do it all over again, so y'all hold on, okay? Okay, ladies and gentlemen, let's do it this way. Notice of non-appearance by a natural person, as I do not wish to submit to gain access to the court. A government branch to obtain redress. Now I'll clean this up. To jurisdiction of E nor and I always do that when I do in order to gain access to the court, a government branch, and we put to obtain redress. Okay, that's going to be your statement. That will be on every page. On every page, and we're going to end that with double exclamation marks. So every page, that will be at the caption. So let's take a look. See, normally that's what people consider the caption to be, is the top portion of the page. The courts have changed the definition for caption, and the caption now means the name of the parties, the case number, that junk, and the name of the court. That's what the court defines as caption now. Okay? So what we're going to do is we're going to leave everything else the same. Now, I put a verified complaint supported by verified affidavit for claim of attempt to defraud my person through a simulation of a judicial process. So they're simulating a judicial process, claiming that they have the right to do this. Now, we're going to list all the elements of fraud. And then we're going to list the elements of conspiracy, showing how the trustee, the bank, and such all came together to defraud you. I just gave you the information I'm going to be putting in here. If you're running out of time, what I'm going to suggest, and you can't wait for me to get the document done, do not call me, do not email me, do not ask me. Okay, because you won't get an answer. I will get to it when I can. I just don't have the time right now to do it now. Okay? Too many other things going on. I have too many other obligations that I have to take care of. Like I said, my conversation with my God today is I want to do this stuff for you guys, but I just don't have the time. There's only one of me. And I'm sorry, there is nobody else who thinks like me. I've said it earlier today, I say it now. If there was other people who thought like me, then this would have been done already. See, you can't bring up TRO because that's discretionary. TRO, as we read earlier today when I did the other one, the case law says is an extreme measure that should not be issued sparingly. Okay, so that's why the courts don't give you your TRO when you ask for it. These attorneys who wrote this knows that. Okay, they know this, but you can get a injunction, which is a TRO, if you bring up the right points. And the way it's going to be written, you're going to be able to bring forth evidence and proof of it. Okay, sorry, I'm closing windows now, shutting screens and so forth. I'll get to watch my tarantulas. Yes, there's a bunch of tarantulas. Said this is the insect capital of the world. There are more insects concentrated in this area than in any other place in the world. And I believe it has everything to do with the high alkaline in the soil. That's my opinion, because that's the only big difference about this area is the alkaline content. So much that I have a 10-stage water filter. Technically, I only need a 6, but a 10-stage water filter for me to drink water. Okay, I go get my water. I don't have to use no filter on the water that I have now, but I'm getting ready to, I got a 500-gallon water tank that I haven't hooked up yet, that I'm going to be hooking up. And thus, the 500-gallon water tank is going to be the main water supply. Okay, this is all temporary. Now that we got Love Ballad in the background, that's this document. We will get to this document at another time. We're going to save it as is, and I will take care of that document at another time. We're supposed to be changing this picture. I'm glad I saw this picture. Ladies and gentlemen, what has happened is that there have been some interesting Penny Mac and other forces that have been interfering with my access to my computer and files. Yes, they've hired a hacker, and they've been trying to cause some problems. So what I've been doing over the last couple of days is shoring up my system so that if somebody does gain access to it, they won't gain access. You know what I'm saying, Vern? You got me? Okay, so that's the issue. Okay? Alright, in just a moment, I will be taking care of a gnat because he's getting on my nerves. It's about time. I've been waiting for these things to download, And so I'm glad that they've taken care of themselves. And I may have to reload this back in because as you see, it's not showing up. So that's the problem. It's supposed to be showing up in the background and it ain't showing up in the background. And that's bothering me. So hold on one more second and then we'll get on to the conversation. I promise you'll love the conversation. All right, everybody, we got some emotions in the background. And I'm hoping that you guys are feeling it too. Now let me explain to you about the emotions that my hope that you all will be feeling. And let me go ahead and clear up my desktop, because all of this stuff is the BlueStacks stuff that I put on BlueStacks. So what we're going to do is we're going to drag all of this over here and we're going to put it over here by itself. I might even just name that BlueStacks. Okay. All right. Now, as I shown in the last video, this is BlueStacks. Now, it's sitting up here not going where it's supposed to be. All right, let me shut that one down because I don't need that right now. We're going to go back to the main page so I can show you guys. Uh-oh, it ain't letting me. Oh well. I am doing quite a bit. And it's an overlay problem because I'm doing the video. And this is a video program. And then I got this video going in the background, and so now what I have to do with this video in the background is I have to pause it because it's not working correctly either, and I'll have to take care of that configuration at a later time. Alright, but again, as I said, this is BlueStacks. Okay, Amazon shopping, and this is a login thing. This is not a login thing. Oh, this isn't loaded. Okay, so we'll get that to load later. And we'll get this to load later. I'll work on all of them later. That's what I get for minimizing and shutting things down. So I will take care of them later. But as you see, Amazon Prime, TubeMate, and weather. And oh, my DNS. Gotta have a DNS. Y'all don't have a DNS. Y'all don't know what y'all doing. Can't be watching no videos and no streaming without no DNS. You need a DNS. Okay? Whew. All right, got that out of the way. Now, get out of the way. You're messing with my screen. Get out of here. All right. Now, ladies and gentlemen, this is what we're going to talk about. Hey, Mariah. Thank you, Mariah. We're going to talk to you in a minute, okay? I know we know what to do. You just go to sleep, all right? That's what you need to do. Go to sleep, Mariah. Ladies and gentlemen, I put Federal Reserve notes have no value. Okay, and they're not redeemable. That's what I put. This is for your benefit, not for mine. That's what the Treasury said. So we want to find the cases where they're actually saying that. Okay, the said lender and their agents checked wire transfer were not backed by or redeemable in gold or silver coin as evidenced by Article 1. This is somebody making this statement. So that ain't working for me. Okay? It says not redeemable by Federal Reserve notes for their value. Now, I'm going to get to this point later. The point that this person is bringing up is that the junk that the banks give you is not backed by anything of substance or value. We're going to talk about that in a second. But and I haven't read any of this, so we're reading it together. I just typed everything in. All of the windows have something specific typed in. I typed everything in, went from one window to the next. I did not look at it because we're going to experience this one together, okay? All right. Testified as to its belief that Federal Reserve notes are not authorized by the United States Constitution, that they are not redeemable in species, and are therefore not subject to taxation. Ladies and gentlemen, that's not what allows them to be taxable. What allows them to be taxable is that they're the property of someone else, and the property of another party has the right to charge interest. Tax is just interest, so that argument doesn't work, okay? Now, argues that the evidence was insufficient to support a conviction on any of the counts because no evidence was presented on the definition of the symbol of, oh, so you decided you were going to take the law in your own hand and you were going to just use symbols and make your own stuff, huh? At least that's what I'm gathering. Now, this one is the Federal Arbitration Act. Didn't know this, but I know it now. Plaintiff claims that the contract containing an arbitration provision was void for two reasons. First, because the loan was under color of law and thereby unlawful pursuant to this. Ladies and gentlemen, again, that argument doesn't work. It is legal tender because it is used to barter and exchange, and it is used by the nation. People have accepted it, so it is legal tender. However, we need to talk about value. Okay? That's why I put Federal Reserve notes have no value. Second, because the contract is ultra virus, because a national bank has no power to lend its credit to another by becoming surety, endorser, or guarantor for him, there are no valid defenses to the enforcement of a contractual blah blah blah. Ladies and gentlemen, they are right. These are arguments. Where's the support? Now, of course, the court is not listing the support. They're just listing the statements. So that's why you're going to support your statements with the case law. You're going to go to case text, you're going to type in the statement, and you're going to pull up all the case law, and you're going to put it all on one page and call it, pay attention, memorandum of law. And you're going to give it a title. Okay, the same as we did our document for you where we put failure to respond, or duty to respond. Sorry, duty to respond is the name of that document that we created. There are several others, but that's the main one. Sellerback claims the Federal Reserve notes are obligations of the United States. They are obligations of the United States that may be redeemed in United States notes. You see, she's saying that this person claimed that. Now pay attention. Redeemed in lawful money pursuant to Section 411 on the endorsement line. Okay, claims that he converts his paychecks into United States notes by stamping redeemed in lawful money pursuant to this. Yes, now technically he could do that, but he didn't explain. You see, by putting the endorsement on there, redeemed in lawful money per 12 U.S.C. 411, he should be giving instructions, not endorsing, but an endorsement is instructions, but he should be giving instructions. It's not an endorsement. An endorsement is to pay to the order of, which is why they're making him look stupid. Now, I'm not saying he is stupid. They're trying to make him sound stupid or that he doesn't know what he's doing. The pay to the order of statement is the endorsement. Your signature is just the authorization. Okay, so when they say please endorse the check, check's already endorsed. They just need your authorization. So without your authorization, there is no endorsement. So when you authorize it, you're endorsing it because now the endorsement receives backing. They're playing words games with you all. So in this case, the notes are obligations of the United States. And they may be redeemed, not in United States notes, because it doesn't say that. It says in lawful money. He's confusing the two. He's not confusing, mixing the two. United States notes are not issued anymore. They have been supplanted by the Federal Reserve notes. That's why if you go legal tender status, it specifically says that the Federal Reserve notes serve the exact same purpose as the United States notes, which the Supreme Court has ruled are not subject to taxation. Really? Wait, hold on. Whew, I gotta see that. See, I haven't seen his documents because what they won't do, trust me, they will not put his documents, they will not put the case law he relies upon. Why? Take a look. All of this right here, no case law from him other than his quote of 12 U.S.C. 411. No case law. But he said, these are the words they take. There you go. Look at that. They cut out a whole section. They quote what they want to quote so that you don't get to hear. Because I wanted to see what case law he was relying on where the Supreme Court has ruled that United States notes are not subject to taxation. So guess what? We're going to copy this. Copy, copy, copy. And then we're going to do this. And I'm going to suggest if you catch something like this as well, you do the exact same thing that I just did. Watch. Tick tock, tick tock, tick tock, tick tock, tick tock. Because all I did was took the statement of the United States Treasury. As soon as it lets me, it ain't letting me do nothing. So we're going to go back here. Oh, it's still spinning, but it ain't spinning no more. It stopped spinning. Stop it. See? Uh-oh, it deleted it. Oh, snap. I was moving too fast. Duplicate. I was moving too fast. Oh, my bad. I apologize. All right, come on now. We're going to do that right there, and we're going to do that right there, like that there. And let's see what's going on. Let's see how this is going to work out in our behalf. Our conclusion is that the United States notes are exempt, and at the time the New York statutes were enacted, were exempt from taxation by and under state authority. Ladies and gentlemen, the gentleman was right. He was 100% right. Look at that. He was 100% right. Now, let me show you. Look, I told you nobody thinks like me. And if they do, they're not telling it to the rest of you. Watch this. Legal. Legal. Sorry, got to turn on the light for the keyboard. TenderStatus. Legal tender status. That's what you put in. Just that simple. Legal tender status. Legal tender status. Legal tender status. Look at that. Legal tender status. Very first one that comes up is UnitedStatesTreasury.gov. 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 I kill you. Okay. Sorry, that was Jeffrey Dunham. I like Jeffrey Dunham. He's funny. Jeffrey Dunham. All right, ladies and gentlemen, paragraph number 7. So 1, 2, 3, 4, 5, 6, 7. Now, hold on. Let's go to paragraph number 8. What are U.S. United States notes, and how do they differ from Federal Reserve notes? I want you to pay attention. Like I said, nobody thinks like this man here. I'm not saying I'm special. I'm just saying I am logical. United States notes characterized by a red seal and serial number were the first national currency authorized by the Legal Tender Act of 1862 and began circulating during the Civil War. During the Civil War. Let's continue. The Treasury Department issued these notes directly into circulation, and they are obligations of the United States government, so he was right. Oh, this is where he got that from. That's pretty good, youngster. The issuance of the United States notes is subject to limitations established by Congress. It established a statutory limitation of 300 million on the amount of United States notes authorized to be outstanding and in circulation. Ladies and gentlemen, for the time and the population, that wasn't a bad benchmark. Why? Not only was it backed by gold, but setting it at $300 million meant that inflation could not take hold. But however, it also meant that there could be a contrition on the currency because someone could hoard it. Such as, let's say, I had 60 million. Another person had 60 million, and we came together and we said, okay, we're just going to hold our money. We're going to keep the 60 million I have and the 60 million you have, which is a total of 120 million. And we're going to hold on to that, and we're not going to let it go anyplace. Okay? Ours is backed by gold. So what I'm going to do is I'm going to take 5,000 and you're going to take 5,000 and we're going to live off of that. And we're just going to watch everything crumble. See, that was the problem with the limitation. All right. Now, while this was a significant figure in the Civil War days, it is now a very small fraction of the total currency in circulation in the United States. Both the United States notes and the Federal Reserve notes are part of our national currency, and both are legal tender. Both the United States notes and the Federal Reserve notes are currency and legal tender. They circulate as money in the same way. However, the issuing authority for them comes from different statutes. United States notes were redeemable in gold until 1933, when the United States abandoned the gold standard. Now remember, the United States did abandon the gold standard. It was not unconstitutional because the people agreed. You guys bringing this argument, you've been bringing the same argument for years now because you haven't been looking at it. The people agreed. They endorsed the new deal or new contract. The people agreed. They needed the consent of the people and they got the consent of the people. The people voluntarily, even though it was under force of threat, voluntarily turned in their gold. Voluntarily they did this, showing implied consent. United States notes were redeemable in gold until 1933 when the United States abandoned the gold standard. Since then, both currencies have served essentially the same purpose. Since then, both currencies have served essentially the same purpose and have had the same value. Because U.S. notes serve no further function that is not already adequately served by Federal Reserve note, their issuance was discontinued and none have been placed in circulation since 1971. Pay attention, ladies and gentlemen. Because Federal Reserve notes have replaced the U.S. notes and they serve the same function, neither of the notes have any value because neither of the notes are backed by gold. Okay, the people willed this. And because they continue to use the notes, that's the way it is. Now, let me tell you the way I think. Because Federal Reserve notes are to be redeemed in lawful money, that documents, according to Section 411, let me make sure you guys see it because it makes no sense for me to mention it. U mama, e mama, the mama, four mama, one mama, one mama, and one mama, two mama, and spay mama, and then their mama. Okay, now the final curtain is being closed. Oh, he's closing. He's taking his final bow. That's right, because it's that time. It is 7:26. I usually go lie down about 9 and then end up asleep by 11. All right, that's my routine, all right? Deal with it. All right, let's get this taken care of. Tonight I'm going to watch me some Automobots. That's right, Transformers. Robots in disguise. But I'm not watching the 1984 Transformers. I'm watching the 2017 series of the Transformers. The cartoon. I said 1984. That Transformer, you know what? I forgot when that Transformer was out. But I do believe it was the late 80s. Anyway, Federal Reserve notes. Federal Reserve notes. Federal Reserve notes are obligations of the United States. Okay, isn't that what he said? But the court made it seem like he was crazy. These are the exact words taken from the statute. That's why I saw that they didn't include the statute. Why is that? Why did the court not include the statute? Because to do so would have infringed upon public policy, because the public perception of the court must always come to the foreground. They must consider public policy, and the public must always perceive the court as being fair, rational, and even-handed. That's why that happens that way. Okay, here's the point, ladies and gentlemen. These notes shall be receivable by all the banks. All of them. Not some of them. All of them. And pay attention. They shall be redeemable in lawful money. So the notes are not lawful money, but can be redeemed in lawful money. Now, pay attention. This statute was written, pay attention, see that date right there? 1935 is the last amendment to this statute. Okay, I want you to pay attention because some of y'all are not paying attention because y'all don't see what's going on. In 2011, Federal Reserve notes are not redeemable in gold, silver, or any other commodity. Now, money is not a commodity, ladies and gentlemen. Shh, 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 don't tell nobody. And receive no backing by anything. This has been the case since 1933. The notes have no value for themselves, but for what they can buy. You know what the notes can buy? Hold on. Let me tell you what the notes can buy. The notes can buy, they can be redeemed for lawful money. The notes can buy lawful money. But he didn't explain this. This is not my presumption or assumption. This is exactly what the code says. You take the letter from the Treasury. You don't need a certified copy. Okay? They already certified it. What do you mean? Well, the Treasury has already certified this letter. What do you mean? Ladies and gentlemen, this is the official website of the United States Treasury. All you got to do is include this webpage. That's all you got to do. A copy of the entire webpage. You provide that to the court. That's your evidence. And you provide an affidavit saying that you downloaded this directly from the Treasury website. And you, if you need to, hold on, you document that right there. This was last updated 2011. No matter how many videos we do, they haven't changed it. I've been waiting for them to change it. Now pay attention again so that you can see it again. The United States notes serve no function that is not already adequately served by Federal Reserve notes. As a result, the Treasury Department stopped issuing the United States notes, and none have been in print and placed into circulation since January 21st, 1971. Now, remember this, United States notes, and as a result, and none have been. Okay, remember those? Remember that right there, okay? Just want to make sure you guys remember that because sometimes, whew, people don't remember things. Okay. See, have had the same value. United States notes, and none have been, and I forgot the other one. Let's see. United States notes, none have been as a result. Oh, it doesn't have as a result. That's the only thing that statement is missing. They repeated the exact same junk they said here in the last paragraph. That means we can hold on to these statements as being factual. Why? Because United States notes were redeemable in gold until 1933. However, the United States notes serve no function and is not already adequately served by Federal Reserve notes. Federal Reserve notes were never authorized by Congress. Wait. Let's correct that. Federal Reserve notes were never authorized by Congress. They were authorized by the United States President, and Congress, pay attention, and in creating the March 9, 1933 Act, authorized Federal Reserve notes. What do you mean? Federal Reserve notes are what the Senate was speaking about in the Senate report as emergency script. Let's do that. Let's do that. Let's do that. Let's do that. Let's do... Where are my Federal Reserve notes? We're going to do that right there. Give me my Federal Reserve notes. Copy. Control C. And action. We're going to talk about mortgages in a minute. And action. All right. Now, we're going to go here. Come on now. I haven't read any of this yet, and I'm doing the best I can not to look at it while we're typing this in. I know some of you are going to go look at it, but what I'm trying to tell you is we're going to go through this together. So it doesn't matter if you look at it. I ain't talking about it until we get there. I'll see you when you get there. Okay, give me a second. Federal Reserve notes are... You see, during the emergency, they needed something to deal with everything. Now, notice what the court said here, 1965. Federal Reserve notes are a common medium of exchange in all fiscal affairs for the nation. Okay, that's not what we're looking for. We're looking for emergency script. So because I didn't find emergency script, what we're going to do is we're going to give me my quotation there, and we're going to give me my other quotation there. And now we're going to do it this way. Because I didn't ask you to look for a keyword search. I want parallel. Look at that. Okay, and it's only because I did it this way. Copy and action. We're going to do a Google search. Why Google? Because Google will give you more search results than all the other search engines. Okay, I want to be able to pick and choose. All right, emergency script note. Interesting, ain't it? 1942 year emergency issued world paper money. Look at that. Pay attention. World paper money. Look, ladies and gentlemen, all I can tell you is I know what I know. Okay? Federal Reserve notes are emergency script. And local currency script banknotes. Now, Congress never said they were emergency script. Congress just gave authorization for emergency script during the emergency. Okay? This is what's going on. Emergency script. Roberts World Money. Roberts, the Bank of Tennessee, Nashville. Note is delicate and well worn. Okay? That's what they do. These emergency scripts, coin emergency script. This is what took place in 1933, ladies and gentlemen. For the United States, Congress authorized Federal Reserve notes in the form of emergency script. All you have to do is read the, what's the word for that? The report, the Senate report for the hearing. Okay? Banknotebank.com, banknote collectors community. So these individuals who collect money know about emergency script. I didn't know it was that popular because I never heard of it except for reading, well, look at that. Sitcom LLC services about us. What is Federal Reserve notes are backed by all the goods and services. Sorry. Ladies and gentlemen, Sitcom LLC is our debt collection organization. The fact that it pulls up is Google and their AI service. Okay, it should not have pulled up. But anyway, the only thing I did was go over those notes from the congressional session on March 9, 1933, where they specifically talked about emergency script. As a matter of fact, let's do that. Let me see if I can. Let me show it to you. Let me see if I can show that to all of you. Now, I don't know what the Sunshine Act was all about, okay, but it says comments for the Sunshine Act of March 25th, 2010. I have no idea what that was about, but it dealt with some type of a panic. Probably because of the great unrest for the getting over on the people with the mortgages, calling it a mortgage crisis when it was a bank crisis, when the bank caused that crisis just like they caused the one in 1933. Yeah, that's what I'm talking about. Now that's what I'm talking about. Okay. Hold on one second. No, we don't need no penny Mac. Where are you? Where are you? It ain't here, so I gotta go here. And come on now. Gotta go here. And then I gotta go to that E fella here. And then I gotta go, where are you? Where are you? Here. And then we're gonna do a search for emergency script. Come on now, give me my able to be pasting. You pasting mother. Okay, stop it. Let's get rid of the quotations because this ain't gonna be no quotation issue. No, we're gonna find several things on emergency here, and I know it in advance. But as I was trying to tell you, I already knew about the emergency script, and there you go. History of money, 1933. Look at that. Pay attention. Dean Acheson to obtain support from the executive branch for emergency script. Ladies and gentlemen, this one I'm going to give some credit for. Taro then shows how 9/11 unleashed the emergency script here in the United States. This one is more so because this one is the whole conversation about the emergency script. Okay? And this is experiment is a success, so it is crushed. Wong, a small town in Australia Alps, faced a massive unemployment during the Depression, issued certified compensation bills. 1 year after the launch of the Warog money, roads were repaired, mayor's office complex were restored, the bills were used in the stores alongside the official currency, and prices remained the same as before because the design of the currency tax were being paid in advance. And in June of 1933, 170 mayors met in Vienna to discuss this particular emergency script. Everyone that attended the meeting were of the opinion that they should introduce this currency in their towns. After that, the Australian National Bank found scientists that proved the attempt to use this new money had to be forbidden. So this Warg had broken Article 122 of the bylaws of the Australian National Bank, and the area administration issued a prohibition order against the use of this money, and it became a criminal offense to issue emergency currency. Nations issue emergency currency all the time, ladies and gentlemen. United States did it in the form of Federal Reserve notes. United States Federal Reserve notes have continued, but that was the plan all along. Okay? That was the plan all along. Now, here's the problem. What you all don't understand, and that's what this individual is getting ready to get into. Emergency scripts were being introduced by every single state. They were all issuing this emergency script because remember, the banks contracted the issuance of money. Gold was being replaced. They needed something to steady things. Hold on. Irving Fisher approached the Undersecretary of the Treasury, Dean Acheson, to obtain support from the executive branch for emergency script. Acheson asked the opinion of one of his Harvard professors who advised him that the system would work, but that it would imply strongly decentralization, decision-making, decentralized banks, and they didn't want that, which he should check out with President Roosevelt. President Roosevelt prohibited any use of emergency currency except by the banks. See, he authorized it. Pay attention so that you guys can understand. Presented a bill to the House of Representatives February 22nd, 1933. The emergency script discussion was already being discussed. If you look at the March 9, 1933 Act, it authorized Federal Reserve banknotes, not Federal Reserve notes. They specifically held a distinction between the two. Federal Reserve banknotes would have been the authorized notes, never issued, but Federal Reserve notes were the emergency script, the same thing that was practiced by all the other governments prior to that and the state governments. So now you've learned something. That's why you saw me put in here Federal Reserve notes. Hold on, let's get there. Are emergency script. And you saw that it did not find anything. So let's do it without emergency script being quotationed. And let's see what we pull up, because I'm interested to see if it pulls up anything about emergency. Now you just saw where we went to pull up the information. All you guys got to do is confirm what I just told you and what that gentleman's website just told you. Okay? Uh, it also states, see Federal Reserve note. Okay, it says banknotes, a promissory note issued by a bank or broker authorized to do so, payable to the bearer on demand and intended to circulate as money. What are you guys reading? Dictionary entry under bank bill. See banknote. Okay, that's why Federal Reserve banknotes were authorized, but not Federal Reserve notes. The Black's Law Dictionary defines a federal law note as a form of currency issued by the Federal Reserve Bank in the likeness of the non-interest bearing promissory note payable to the bearer on demand. You see, that's why Federal Reserve notes were supposed to be redeemable. Here's the problem. You can't redeem it. The Treasury won't let you, won't tell you how to. Okay, so we're going to get to that soon. So be patient. It's going to take a minute. Can't tell it all to you in one day. So be patient with me. The deposit was reported to the Federal Reserve Bank pursuant to the instructions embodied in Exhibit 3. Okay, ladies and gentlemen, those of you who are trying to put our-style money orders into bank accounts and you're trying to pay the Federal Reserve and all of that, I'm going to tell you to be cautious and careful. You're going to have to wait until we get through this credit series to get a better understanding. The notes are composed of the authentic Treasury Department paper used to print genuine Federal Reserve notes. Reprinted bills process many of the unique security features of genuine currency. This is forgery that they're talking about in 2009. And this person, the circuits that bleached and reprinted notes are altered. Basically, they were, putting fives on tens and things like that. This includes, no doubt, Federal Reserve notes. What includes, no doubt? It means the currency authorized by the United States government. So basically, commonly known as greenbacks, the certificates of deposit, commonly called gold and silver certificate, issued by the United States. Okay, this includes, no doubt. No, don't do the no doubt. Either it includes or it doesn't include. It is charged gold or silver certificates, treasury notes, Federal Reserve notes, national bank notes. See, when was the last time you seen a national bank note? Or part of one kind or part of another. The law presumes the defendant innocent. To hold that this description advise him of the nature of the charge would, okay, this would be, I believe, the attorney for this individual in 1923. Ladies and gentlemen, if I were you and you're interested in this, I would take a look at that 1923 case because it would give you a whole lot of understanding that they are not talking about now, but that the foundation is there because the courts are very good when they don't want you to see what they're talking about. They will say, well, this person says this, or it's the person's argument this, and even though they see the law says this, or excuse me, the statute says this or that, Federal Reserve Bank itself omits a suffix in serial number lists it sends to the banks and other financial institutions. And I believe this might be on forged bills and all of that stuff. Doesn't matter. Not looking for that either. Made Federal Reserve Bank form. No, the data is available at the Federal Reserve Bank and provided in the tab, blah, 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 blah. Not that either the notes involved are printed form. Nope. This made closing daily balances and a statement of the bank prepared and furnishes differ bank records. No, no, no. Transfer journal kept by the banks contained the following. None of that is anything talking about Federal Reserve notes being emergency script. So we can get rid of that. Now let's get back over here because this is what we're here to talk about. Our conclusion is that the United States notes are exempt. Our conclusion is that the United States notes are exempt. And at the time New York statutes were enacted, were exempt from taxation by or under state authority. Now, claims the Federal Reserve notes are obligations of the United States. This was the case we just read, and he was right. He didn't claim it. The court stated it. Okay, he didn't claim it. Endorsed line in each of his paychecks asserted, okay. And you notice all three of them say the same thing, even though I didn't put his case in here. That's 5 already of the same case. His Honor holding that neither the United States Treasury notes nor national bank bills were subject to taxation by the state. This is 1873. Bills are not. Then that $81 shall be stricken from the list. The commissioner refused to alter the list, and the plaintiff appealed to the Superior Court, and the court directed the commissioner to correct the list by striking out $162. His Honor holding that neither United States Treasury notes nor national bank bills were subject to taxation by the state. Whether that be so or not seems not to be necessary for a discussion in this case. Why not? Why not? Why do you not want to discuss that? Because it is plain that the plaintiff had neither United States Treasury note nor national banks bills on hand or on deposit. Look at that. They said they didn't want to discuss whether or not United States notes can be taxed. Do you understand what they're saying, ladies and gentlemen? Because I don't think some of you do. What this person was saying when they went, okay, let me see if I can explain it to you in much greater detail than they're doing here, because they're not giving you the details. The plaintiff subsequently applied to the commissioner to correct her tax list, assigning that the reason that the deposit was made in United States Treasury notes and national bank bills, and that they were not subject to taxation by the state, because you cannot tax the sovereign. Those notes were issued by the sovereign and cannot be taxed, because the sovereign issued the notes. The sovereign cannot be taxed. This is what the young lady was saying. This was the law back then, and this was what the judge ruled. Let's see if I'm correct. The amount of the tax was $162, and she asked to have that amount stricken from the tax list. Or, if the United States Treasury notes are exempt and the national bank bills are not, then that $81 be stricken from the list, half and half, okay? The commissioner refused to alter the list, and the plaintiff appealed to the Superior Court, and the court directed the commissioner to correct the list by striking $162. Why? Because the government authorized the banknotes, and the government issued the notes by the Treasury. The government authorization and the Treasury makes the notes exempt from taxation, because the government cannot be taxed. His Honor holding that neither the United States Treasury notes or the national bills were subject to taxation by the state. Please understand, that is the argument some people have been trying to make. As I'm reading some of this case law, I'm getting that. Let me say this to you. You will not win with that argument, because that cuts into the national policy of making the people think that their taxation is nothing other than voluntary. You all have the right to be tax exempt, you just don't do it. You all have been given an EIN number. Go ahead, done too many videos. And you all have been given the right to operate under that EIN number and to write off all of your debts. And you're not doing it. Whew, Lord have mercy. Now let's see about the public policy, so that you can understand that that's what the courts are going to continue to do. Whether that be so or not seems not to be necessary to discuss, be necessary to the discussion in this case, because it is plain that the plaintiff had neither United States Treasury notes nor national bank bills on hand or on deposit. Really? Why not? Why not? Why didn't it? It was the commissioner. Why didn't he? It doesn't matter whether or not he had those bills on hand. It's whether or not he was supposed to correct the ledger. Okay, it is true that she deposited $1,500 with that bank, but it is not a special deposit. As a package to be kept for her and returned in kind when she called for. If so, the money and the very money deposited would have remained hers, but it was a general deposit entered to her credit. As I told you, when you deposit money in the bank, it is a credit. They credit your account. Non-returnable in kind, but payable to her order with interest. Pay attention. They're telling you how the system works. I've been shouting it for years. Literally, been yelling and screaming it into a microphone, trying to tell people this is how it works, but nobody's listening. They seem to think I'm just talking out the side of my neck, that I'm just making this stuff up. So it would seem that she had no money at all and ought not to have listed any. Really? She deposited $1,500 in the bank, and you're telling me that wasn't her money? No, because the bank took it and converted it to credit. That's what they're telling you. But still, having listed it improperly as money, the question remains, must the defendant strike it out? Suppose it was wrong to list it as money and right to list it as a credit, and the tax is the same on each. It would seem to be a vain thing, to strike it out of one column and put it onto another. What the plaintiff desires and what she asked for is to have the item of 162 deducted from the aggregate. Ladies and gentlemen, did you hear what they just told this lady? You're sitting up here. Look, suppose, pay attention, suppose it was wrong to list it as money and right to list it as credit. Pay attention. The tax is the same on each. No, the tax is not the same on each because the government can't be taxed. That's why the Superior Court judge ruled what he ruled. That's why they don't want to discuss that. See, they're only interested in the taxes. They want the money. It would seem to be a vain thing to strike out one in one column and put it into another, because it's saying that the tax on the money and the tax on the credit are the same. You can't be taxed on credit. How can you be taxed on your own credit? You deposited the money into the bank. How can you be taxed on your own credit? The bank is crediting your account. That's your credit. You put the money into the bank. They're crediting your account with your credit, not their credit. Interesting, ain't it? Shh, don't tell nobody. If I were to go in court, they would sit up there and make me appear to be a fool when they know what the law is. Now, if the aggregate is not to be changed, then it makes no difference with her in what column the item stands. Why would it not make a difference? Shouldn't the record be correct? The plaintiff's counsel answers this view by suggesting that if treated as a credit, she would be entitled to deduct from the amount any debt which she may owe, and that is true because it's hers. The difference might have been avoided if she had alleged in her petition that she was not liable to list it as money for the reasons given, nor as a solvent credit because she was indebted in such a sum. Now look, did you see what the court just said to her? Because you said it was money, that you deposited money, you can't bring that argument. But wait a minute, that wasn't the argument. They said they didn't want to consider the real argument, that you can't tax me on government money. But when you deposited it to the bank converted it. Yes, but you're not charging me on what they converted it in. You're charging me on the deposit. And her attorney should have argued that. You're not charging me taxes on it after it was converted. You're charging me on the actual deposit. You can't convert it until after you receive it. You're charging me on the receipt. You're not charging me on the aftermath of the receipt. The taxes are on the receipt of the monies. You follow me? Her attorney didn't do this. Because he didn't do this, the court got to bring up the fact that, hey, doesn't matter. If you had not mentioned that it was money, but mentioned that it was credit and that it was solvent credit, you know, because she was indebted in such a sum, but she makes no such allegations, and therefore we suppose, we guess, we presume the fact is not so. But still, as it seems, not to have been considered in this light, either in the court below, or by the commissioner, or by the plaintiff in her, then why are you considering it if it's not part of the case? She ought to have had an opportunity of showing that she does not owe debts which ought to be deducted from her credits. So, ladies and gentlemen, we have been a solid credit system since 1933. And it's because of this ignorant line of thought that things exist the way it is. Now, this was more than likely a circuit court of North Carolina because she had already gone to the Superior Court. So this was more than likely a circuit court. Okay? Now, I'm going to do one final thing. We think His Honor was in error in holding that the plaintiff's deposit remained her money. Why? It was her deposit. She put it into the bank for safekeeping. Isn't that what a deposit is? Stop it. Because they've changed the terminology. They've changed the understanding of what it is. It's supposed to be kind for kind. You're supposed to be putting it in the bank for safekeeping, and that's why they charge you interest. Remember, that's what IOUs were for. That's what the whole redeeming it in lawful money was all about. You were to redeem it in gold. That's what that whole thing was about. You put it in the bank for safekeeping. Well, she didn't do it as a special deposit. She wasn't supposed to do it as a special deposit. The bank understood what her intent was. They did not tell her that, oh, we're going to take your money, which is backed by gold, and we're not going to back it by gold. We're going to give you credit. Remember, this was before 1933. You're not paying attention. This is 1873. They've been playing these same games all this time, people. Anyway, and that he ought to have held it to be credit, to be listed subject to any debt which the plaintiff owed, and that he ought to have had an inquiry into that fact. The judgment below is reversed, and if the plaintiff move, the case will be remanded that the fact of the indebtedness of the plaintiff may be inquired into. Now, what I would be moving is for somebody to prove to me that I intentionally was depositing something into the bank to be converted into a credit. Go ahead. Let me know where that was part of our contract, part of our agreement. Anybody? Because they can't answer it. And this was, let's do this. The point most discussed at this bar was whether the United States Treasury notes and the national bank bills were liable to taxation by the state. And although, as we have seen, it is not necessary, pay attention, it is not necessary to discuss this in this case, yet as His Honor's judgment was based upon it, then yes, it was necessary. And as the matter of general interest, it may be proper that we should express an opinion on it. Of course you have to express an opinion on it, ignorant mother. I'm sorry. I get so tired of this ignorance that goes on in the courts. It seems to be settled by numerous cases of the United States Supreme Court cited that the plaintiffs believe, or a brief beginning with McCulloch, anyway, and the state of Maryland, the United States Treasury notes cannot be taxed by the state because they are a means of use for the support and administration of the United States government. So are Federal Reserve notes. I want you guys to hold on to this. This case is right here. Ruffin versus Commissioner of Orange County. Okay, 69 space capital N dot capital C dot, meaning North Carolina, space 498 comma 510 open paren N period C period space 1873. That's the case site. Okay, let's continue. And if a state could tax them, then unfriendly states might so tax them as to destroy the usefulness, and in that way, to that extent, destroy the United States government. Do you see? Public perception. And there's the fear that they have to pump into the public, making them think that that would be possible. So they are not taxable. Federal Reserve notes are the obligations of the United States. You saw, wait, hold on. I ain't going, this ain't my words. Okay? Federal Reserve notes are the obligation of the United States. So if Federal Reserve notes, you heard me, right? If Federal Reserve notes are the obligation of the United States, then they are non-taxable. So how can you be taxed on your Federal Reserve notes? Well, you're not being taxed on your Federal Reserve notes. You're being taxed on your labor. You're not being taxed on the notes. You're being taxed on your labor. The notes are being issued to you in exchange for your labor. Okay. These national bank notes or Federal Reserve notes seem to be a debatable question. The case cited against the power of the state to tax the U.S.C Bank in Fino, we do not think that case supports the position. It is there decided by a divided court that Congress may tax the circulation of bank chartered. So Congress may tax the circulation of banks chartered by the state, and that although the tax is so heavy, about 16%, as to destroy them, it is not pretended that this tax could have been imposed if the bank had been chartered for the use of the state and as a mean of administering its government. But it is put up on the grounds that they are corporations for private profit. And the power of Congress to tax the circulation of banknotes depend on whether they are for use of the state government or for private profit. Again, commercial use. Pay attention, private profit is commercial use by a corporation. That's why you will see in many of the documents and many of the statements I make is that they are private for profit corporations. Okay? So, let's continue. So the power of the state to tax the circulation of national banks depends on whether they are for the use of the United States government or for private profit. Congress can only tax you if you are for private profit or gain. Go back, look at the video where I just talked about taxes, where they cannot tax you on your private property, your household goods, because you are considered the government of your home. A man's home is his castle. Now, I'm sorry, that's an argument you're going to have to put together, but you're going to have to use cases like this in order to do it. All right, now that's just one point. Let's go to the next. Some of you who are in the finances, you're going to get this stuff, and you're going to get it, you're going to get it, you're going to get it, and you're going to understand it. Okay. Which the United States Supreme Court has ruled is not subject to taxation. Salabak elaborates his belief that the law provides access to lawful money upon demand and assures full discharge of all obligations upon assignment or transfer of payments to the United States. Technically, he is 100% absolutely right. By assignment to the United States or transfer. Ladies and gentlemen, he is 100% right about that. And this guy right here, I don't know where he is, what year this case was, This was, I can't see the case site. All right, we'll get to it in a minute. We'll get back to the case site. All right, let's finish what was saying about this young man. Salbach contends that his tax returns were based on a frivolous position. No, based on a presumption, because he complied with the law. Salbach further argues imposing a frivolous filing penalty violates 12 U.S.C. 95A2, which no longer exists. Okay. Okay, let's see. U.S.C. 95A2 is no longer valid. United States. Wait a minute. Hold on. How could it no longer be valid? Interesting. I'm going to have to read one of those cases. You know what? That's interesting. Hold up. Now you saw what I did. You saw me click on it, right? Oh, okay, cuz let me see. Let me see. I don't see, I'm looking for 2. I see A, but I don't see 2. Yeah, it says omitted. I need to pull up the actual, 1 second. Ooh, wait, because if this is what I think it is, but they say it's no longer valid. So let's Google that mother. Okay? Now hold on, we're gonna go back because they said it's no longer valid. Now that's my first time hearing it recently. I heard it before, but I didn't see it in print like I'm seeing it now. You know what I mean? Okay. So it says no longer valid. In these cases, omitted United States Code effective December 2000. Oh, wait, look. Was omitted from the United States Code effective December 1st, 2015 because an identical section exists in 50C and has since 1941, even before it was omitted. However, the statute related to president's authority. Okay, thank you. Ladies and gentlemen, do you know what these idiots just did? When they say that section U.S.C. 2, 9A, U.S.C. 12, 95A2, when they say it's no longer valid, they're right, it's no longer valid because it has been recodified here. So let's go there. Okay? I didn't mean to do it that way. Dag nabbit, I messed up. Okay, I was supposed to do a Google search on this. I wasn't supposed to be going here like this. But it says, the president, if he shall find it compatible with the safety of the United States and with the successful prosecution of war, may, by proclamation, suspend the provisions of this chapter so far as to apply to an ally of an enemy. And it doesn't apply because you're an ally of the enemy. And he may revoke or renew such suspension from time to time, and the president may grant license, special or general, temporary or otherwise, for such period of time, and containing such provisions and conditions as he shall prescribe to a person. Sorry, there was a bug on my screen and he had to go. I ain't got time for that. To any person or class of persons to do business as provided in this section. Section A, 4304 of this title to perform an act unlawful without such license, and section 4303 of this title to file and prosecute allegations under this subsection. Section 4310 of this title, he may revoke. Another bug gone bye-bye. Yep, he's dead. Sorry. All right. They just, you hear taps in the background, don't you? Ladies and gentlemen, this is what the President of the United States did under Presidential Proclamation. That's why it's under 50 U.S.C. But even 95 U.S.C. is also trading with the Enemies Act. Okay? So this is what the thing is. During a time of war, the President may, through any agency he may delegate, and under such rules and regulations as he may prescribe by means construction license or otherwise, investigate, regulate, prohibit any transaction, foreign exchange, transfer of credit, or payments between, by, through, or banking institutions, and importing, investigate, regulate, and all of that. This is the Trading with the Enemies Act, ladies and gentlemen. Okay? By a person, any such person, interest, blah, 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 incident. Nope, I don't want to copy that. Trying to scroll up. Furnish under oath the form, likewise necessary to enforce. No. Under the custody and control of any payment, conveyance, and United States amount under full acquaintance and discharge. Acquittance, excuse me. This is the section the young man was using. Now, I want to show you what the courts did. We're going to read this because you need to hear this. This is the law currently. Any payment, conveyance, transfer, assignment, or delivery of property or interest therein, made to or for the account of the United States, paid to the United States of America without recourse, or as otherwise directed pursuant to this subdivision and or rule, regulation, instruction, or direction issued hereunder, shall to the extent thereof be a full acquittance and discharge for all purposes of the obligation. Ladies and gentlemen, here's your discharge. Here's your discharge. Now, I'm not going to tell you to do this. I'm going to tell you A for B that motherfucking bill to the United States of America. No person shall be held liable in any court for or in respects to anything done or omitted in good faith in connection with the administration of or in pursuance of or reliance on this subdivision or any rule, regulation, and or instruction directed issued hereunder. You don't need the other part. You need this part right here. You're going to have to study this. Here it is, 50 U.S.C. 4305. As a matter of fact, I don't know, I'm going to take this and this is going to be your discharge. Everybody's been talking about how to discharge their bills. Well, why don't you do a remittance coupon to the United States, any amount of your bill, attach an affidavit saying this is what you're relying on. Don't take my word for it. Don't take my word for it. Do your research. Let me tell you what the court did so you can see. Now, Congress got rid of this, but they didn't get rid of it. They just omitted it and moved it over someplace else because too many of you were using it. From 2012, this is the code everybody and their grandmama was using. 12 U.S.C. 95A. Go back and look at the videos. All of them were using this. They took and they moved it to a different section. It hasn't been gone. It hasn't been done away with. This is your discharge. It says it right there. Now, I'm going to stop this video because I think that we done discovered something. Now, let me tell you why I believe this. Let me tell you why I believe this. No, we're not here. We got to go here. This is the case. And I want you to listen to, now, see, that's what's been happening. Okay? That's what's been happening. This is the gameplay that's been happening. And I'm okay with that. I can handle that. Because I'm glad it takes me right back because this is where we were. 12 U.S.C. 95A2. Stop using 12 U.S.C. 95A2. Why? Because it's no longer valid. Now, because he used the code, they held him to the code. Don't use the code. Use the positive law title. Now, watch this. And ladies and gentlemen, there is no voice recognition going on. The fact that it keeps doing that, that lets me know that the idiots are still doing what they do. And it's okay because let's see if we can do so that we can put a stop to that. All right. So we put a stop to all that stupidity. Okay? Because what it will do is take me right to where we need to be because that's what we need. This is the section we need. We'll come right to this in just a second. We have to do something. Okay? So And you notice how they keep saying no longer valid, no longer valid, no longer valid, no longer valid, no longer valid. So we're going to do this. There we go. Whew. We're going to do a Google search on this mother. So we're going to search. Where's my search at? It don't want me to search. Oh, because it's a link. That's why it don't want me to search, because it's a link. So what we're going to do, don't want me to search it that way. Well, I'm going to search it this way. There's a reason I did it this way. I could have just opened the window and typed it in. Watch this. POSIT. Okay, I don't care about this right here. What I care about is Title 50, Positive Law Title. Okay, so let's find out. We're going to go to United States House of Representatives, US.gov, and we need to find out if Title 50 is a positive law. So where's the numbers at? I know some of you already know, but I'm showing this to everyone else. Where is the numbers at, people? Okay. Links to current completed positive law codifications. So 50 is not in this list, but we're not worried about that one because that's not the complete list. This is the ones that they've just added. So I'm looking for the complete list. Positive law codification, the term positive law, we already have that information. Positive law, non-positive law, list of current and recently so that's not it. I'm looking for all positive law codification, not no brochure. I'm looking for all of the positive laws. These are not all the positive laws, ladies and gentlemen. So we're going to have to go back. I'm going to have to go back to a page that's actually going to give me all of the positive law titles. So watch this. We'll do it easier. Like Sunday morning, Tuesday morning, Wednesday morning. Okay. Watch this. ES. Hey, there it is right there. I was just about to put list of positive law titles. Okay, where is... There it is right there. Uh-oh, it's a non-positive law title. Okay, so guess what you have to do? Look, Title 50 is a non-positive law title. So it's not prima facie evidence. Well, technically it is prima facie evidence. But because Title 50 is a non-positive law, now you got to find... Okay, let me show you. Make it easy on you so that you guys don't have to be going all over the world. I've been around the world and I can't find my baby. I don't know and I don't know why. Okay, ladies and gentlemen, this is the section that ally with the enemy. This is the section that we were looking for. So let me show you how you get the positive law title. Because right now, this is not positive law. Because we just found out it's not a positive law title. Remember, the law is not the law, it's the title. Okay? So, Stat 40, Stat 415 is the original. This is where you go to get what you're looking for. Okay? And in order to get what we're looking for, we have to do a Google search. A Google search, a Google search. So we search through Google. Okay? To remove the powers of the president to regulate transactions during national war. So comprising Trading with the Enemies Act, which was amended in 1977. No. Ladies and gentlemen, it was amended 1977. They're absolutely right. With the National Security Act, the National Emergency Act is what it was called. Okay? But it wasn't removed. It was not removed. Why? Because the presidential proclamation, this is directly associated with the presidential proclamation. It was not removed. It is still extant. We already done talked about that. So this is GovInfo, and this is, I'm going to definitely download this PDF because we already done gave you the information on still extant. Now, if you don't believe me, just go Presidential Proclamation 2039 still extant. Now, give me a second. I need to check something. I'll be able to tell you in a second. I really do hate this because this is not the statute at large. And I'm looking for the statute at large. This is the codification. You see where it says banks and banking? This is the codification. I don't want the codification. I want the statute at large. Okay? I want this actual stat. So, let's see. Act of October 6, 1917. This is the Trading with the Enemy Act. Let's see if this is going to give me the actual, because I don't want the code. The code is not law. According to Congress, their law is statutes at large. Okay, so I want the actual stat at large. And that's why we're going to come here to this lawyer site and see what they got. Yeah, see, they talk about the codification, they talk about the amendments, they talk about the transfer of functions, expense of compensation, and executive order. What year was that? 1971. Nobody cares about that. Transfer of certain functions. Nobody. Well, you guys are going to have to care about this. You're going to have to read over this because this is that history. If you want to go ahead and write off stuff. Oh, look at that. They have Roosevelt right here. Notice this. Office of Allied Property Custodian shall submit to the Bureau of Budget, now the Office of Management and Budget, an estimate of the General Administration offenses, and it's signed by Roosevelt. But this is not what we're looking for because this was 1943. So this was years later, after 1933. So what I'm looking for is the stat. Anybody can find me the stat at large? I would appreciate that. You would appreciate it too. Stat at large, 40. And I know there's a website where you can go and get the statutes at large. I'm looking for this statute at large. Okay? You know what? But not the 1917. Not the October 6, 1917 Trading with the Enemies Act. We're looking for March 9, 1933. That statute at large. The reason why you're looking for that statute at large is because that's the one that's still extant. Okay? Now, let's go back because we got to get back to where we came from. Nah, we don't need this. We don't need this. We're going to go back to casetext.com. Now, we're going to read this, and then I'm going to let you guys get on with your day. I promise you, if you don't think that Title 50 of the United States Code, Section, what is that, 4305, is your bread and butter, when you attach, because remember, it's prima facie evidence, so you got to attach the statute at large. Because prima facie evidence is the positive law title. The positive law, remember, there's a title and there's a positive law. Positive law is statute at large. It is prima facie evidence of the actual law of the land. It's just the way it is. Sorry, I didn't make up that junk. It remains to address the two documents the defendant filed September 27, 2018 hearing. As I noted at the hearing, however, the document and the argument they represent do not appear to have any basis in law. Well, it doesn't appear, ladies and gentlemen, it doesn't appear. Why doesn't it appear? Either it has a basis in law or it doesn't. Look, it says, Mr. McLaughlin appears to assert that the issuance of an indictment against him somehow made him an unwilling recipient of the trust of the United States. Did it or didn't it? C, termination of trust. You can't terminate the trust. It's an irrevocable trust. You can't terminate it. Whereas one cannot be forced or compelled to become a trustee. That's a lie. Ladies and gentlemen, that is a lie. Okay, that is a lie. One cannot be forced or compelled to become a trustee. A trustee doesn't even need to know that they've been appointed trustee. Please. Ladies and gentlemen, whereas one cannot be forced or compelled. Now you see how they put it in brackets? Pay attention. They do that on purpose because it's not part of the document. Do your research. Raymond McLaughlin held to be the trustee in this case since June 8, 2017, when the United States bifurcated the title to the True Bill indictment and deceptively served upon Raymond McLaughlin the legal title to the True Bill indictment. Hereby now assign, transfer, convey, and deliver said legal title to the United States, the holder and beneficiary title, thus merging both beneficiary and legal titles of the United States, which terminates the underlying trust in the case. You know what? Good idea. But he did the assignment pursuant to 12 U.S.C., an invalid code. You can't do it. You have to do it pursuant to Trading with the Enemy Act, October 6, 1917, and the amendment of the Act, March 9, 1933, under the congressional article, I believe it's Article 1, Section 8. That's how you do that. You do not mention something that is inapplicable. Now, that's why they're pointing out. That's why they put it in. That's why they put it in parentheses. What took you that long? Ladies and gentlemen, hold on. Let me show you. I was working on BlueStacks, and it was downloading and fixing things, and it was uploading and all of that. So, all right. Yes, I accept. This company, I actually paid for their service. All right, come on now. I said I accept. Now get on out of the way. Shoot. Go on now. See how it's like a cell phone? And no, we're going to continue for free for right now. And then we're going to start. See how it looked like a cell phone? That's what it is. Now, what I want to do, there you go. Let's get back. That's Prime Video. See, what it did while we were doing all that talking is it was loading up all of these bad boys. Okay, it's still got this one. It's got to finish. 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 And this. It's got to finish. Okay, but right now it's loaded up Prime Video. And that's from time to time. Maybe I want to sit up here and watch a bigger screen. Okay, see? Hey, come on, Prime. Oh, I know why. I haven't logged in. I have a Prime account. So, oh well, take care of that later. All right, let's get back to this, ladies and gentlemen. See, the court highlights this right here because it's invalid. And you're going to see in a moment. They're going to highlight invalid, invalid, invalid. It's not his process was invalid. His process was not invalid. He did the right thing in terminating. See, he collapsed the trust upon itself. Why? Because he merged the beneficiary titles, the legal and the beneficiary title. This person, Mr. Raymond McLaughlin, this is no fool. I like him. I ain't joking. I like him. I like what he did. He just didn't complete everything. And he relied upon prima facie junk that couldn't support his position. Because remember, it's all about documentation. Documentation is everything. And he didn't properly document the case. Raymond McLaughlin held to be the trustee in this case since June 8, 2017. Is he saying that? Is the court saying that? Pay attention. Raymond McLaughlin held to be the trustee in this case since June 8, 2017, when the United States bifurcated the title of the true bill of the indictment and deceptively served upon Raymond McLaughlin the legal title of the true bill. Now, the true bill is a bill. So he was absolutely right. And he had that bill can be endorsed because it's not endorsed. If you look up the definition for true bill, it says indictment. That's why the court put indictment in parentheses. They know what he's talking about. Hereby now assigns and transfers, and this is what he's saying. Hereby now assigns and transfers, conveys, pays, and delivers said legal title to the United States. Look, he did his assignment. Did he acknowledge it? With every assignment, there must come an acknowledgement. With every order, there must be a bill. So when the judge charges, or when the attorney general charges the grand jury, that's an order. They produce a bill. With every order, there must be a bill. So he takes the bill and he endorses the bill. That is what he's supposed to do. The provisions of the, pay attention. I want you guys to, I want to let you see this, because if you don't pay attention, you will miss it. They are not saying what he did was incorrect. They're saying that he relied upon a clause or a code that was invalid. The provision of the United States Code, McLaughlin cites, however, is no longer valid. He completed the process, but he used an invalid law. God, ladies and gentlemen, this is what I was doing to get people out of jail. I wasn't using all this language. It was unnecessary. I wasn't using all this language. I was just taking the true bill, endorsing it. It's a bill. I was A for being the true bill. Okay? While A for being the true bill, you can use all the language that Mr. McLaughlin used. You can pull up this case, United States versus McLaughlin, and this is a 2018 case. Okay? District of Connecticut, October 5th, 2018. Now, they say that the provision of the code that he relies upon is no longer valid. But hold on. They don't say anything about what he just stated about collapsing the trust was invalid. And they might talk about it later, and I don't care. It's too late. They should have talked about it first and said later that the code he used was invalid. But they're saying the code he used was invalid, and then they highlight it again, no longer valid. Okay, nothing and blah blah was omitted from the United States Code effective December 1st, 2015, because an identical section existed here and has since 1941. So the code still exists, and this is what you use, is the fact that the courts recognize the code still exists. And they give us, we're going to come back to this section, okay? We're going to come back to this section. Oh, it's not going to let me go to 13. Yeah, I clicked on 13. It's supposed to take me to 13, but that's okay. In any event, as noted at the hearing, there is no basis in law for the defendant's argument. The issuance of an indictment does not... Oh, now you're going to take me there? After all that time? Aw, that is so special. Like I told you, this is not my doing. This is the way the system wants to play games. And I'm okay, because the information that we are talking about right now is 100% necessary. So hold on. Let's get back to our no longer valid issue so that we can move on with this video. And then I don't know, I know it's been over an hour. And so let me put you guys on pause so it doesn't take much longer. Okay, now you see how the court is saying that it has no basis in law. Interesting, huh? So are you telling me that, are you telling, and you must be telling everybody, that the court is not dealing with trusts, and the court is not overseeing trust accounts, that the court is not an equity court? That would be interesting. Now, let's do this. Want you guys... It says, the issuance of an indictment does not create a trust of any kind. Ladies and gentlemen, pay attention. The issuance of an indictment does not create a trust of any kind. You're right, because the trust exists before the indictment. And the defendant's return of the indictment cannot divest the court of jurisdiction over his case. He wasn't trying to divest the court of jurisdiction over his case. Okay, he was trying to collapse the trust, not divest jurisdiction. Jurisdiction remains. The trust was supposed to become invalid. Take my word for it. I know exactly what he's trying to do. Although the two documents in question are not styled as a motion of acquittal, I treat them in that way in light of the relief they seek and defendant's immediate release. Okay? Do you see how we're going to construe the documents this way instead of the way they're being presented to the court? They know that they're dealing with trust. Okay. Now, this was 13, that's why I didn't move, deals with wartime powers of the president and concerns certain transfers of property. It has nothing to do with this case. Actually, he didn't say it had something to do with this case. He didn't say that 95A had anything to do with this case. He said he was operating under 95A in order to discharge this debt. That's what he said. But again, like I said, what the courts are going to do is take what you say and twist it around. That's why you got to support it by evidence. Okay, for these reasons, I denied the defendant's pro se motions. Now, they weren't motions. And that's what he has to go back in on the record and document. I know they probably found him guilty. Now notice this. For the reasons set forth above, the defendant's motion for judgment of acquittal, motion to dismiss the indictment and or impose sanctions, and motion for a new trial, and the defendant's recent pro se filings, to the extent they are motions, are denied. It is so ordered. Ladies and gentlemen, pay attention. Pay attention. I want you to understand what's being said here. For the reasons set forth above, that law doesn't exist anymore. The defendant's motion for judgment of acquittal, motion to dismiss an indictment and impose sanctions, the motion for a new trial, and the defendant's recent pro se filings, to that extent, they are motions. He didn't title them motions. Well, he did title some of them motions. See, motion for a judgment of acquittal. Motion. Ladies and gentlemen, stop motioning the court. There's no reason you should be motioning the court. You should be petitioning the court. Supported by affidavit. So a petition for a judgment of acquittal, supported by affidavit. A petition for dismissal of indictment, supported by affidavit. A petition for imposition of sanctions, supported by affidavit. A motion for a new trial, no. A petition for a new trial, supported by affidavit. Do you understand? You do it in affidavit form. You put all your evidence in there and you sign it, and do it under penalty of perjury. Don't be afraid. Don't be afraid, because that makes it a verified affidavit under their so-called rules of court. Now look, to that extent, they are motions. To the extent they are motions, are denied. Well, what about the extent they are not motions? What are you going to do then? Because he didn't articulate it. So this young man is in jail. And I'm sorry to hear that. They convicted him. And he is no slouch. So ladies and gentlemen, if you can get in touch with this young man, I promise you, just let him know that he was right on the money. That he did not miss a beat. The only thing he did was he quoted the wrong statute. Tell him to go over 50 U.S.C. 4305 B2 and the Trading with the Enemies Act, October 6th and March 9th, 1933. Now, pay attention. I want you to see. You guys are not going to believe this because I didn't make this up. They made this decision on the 5th of October, 2018. It's the October 6th Act, 1933. October 6th Act, 1917. October 6th Act, 1917, and this was done October 5th, 2018. I'm a puzzle person. My mind sees puzzles in so many different things. This would have been the 101-year anniversary of the Trading with the Enemies Act. This was a criminal filing that the United States brought against him. He did everything correctly. He just used the wrong codes. I keep telling you guys, you got to do your research. So this is the code. As a matter of fact, when I do this video, this is going to be what I'm going to put as the title. I ain't lying. I ain't lying. Okay? Ladies and gentlemen, endorse the indictment. Put a dollar amount on it if you'd like. Endorse the indictment. Put a dollar amount on it if you'd like. Wait. What does this thing say? Okay, suspension of the provisions related to ally enemy, but I saw something gold. Yeah, foreign exchange of gold and silver property. Well, that's not what I'm trying to do. I'm not trying to do no HTML. But ladies and gentlemen, get the indictment, certified copy of the indictment, the true bill. That's the charging instrument. Endorse the charging instrument. If you want to put a dollar amount, pay it to the order of the United States of America, or you can even, what we were doing, we were paying it to the order of the court. Pay it to the order of the clerk of the court. Because he has a debt to pay to society. She has a debt to pay to society. They have a debt to pay to society. Pay the debt. And then discharge that same debt to the credit of the United States. Don't discharge the same debt. You know how they were doing the A for V? Pay the same to the account and they will put their account? No. Discharge the same debt to the credit of the United States of America without recourse. Sign it without recourse. Send a copy to all of the powers that be, including the Supreme Court of the United States. Document the fact that this system has been founded on your ability to discharge a debt. You are not making this up. This is not your thinking. This is what the actual law says. The law says any payment, conveyance, transfer, or assignment or delivery of property or interest therein made to or for the account of the United States or as otherwise directed pursuant to this subdivision or any rule, regulation, or instruction or direction issued hereunder shall to the extent thereof be a full acquittance and discharge for all purposes of obligations of the person making the same. Acquittal. Okay? No person shall be held liable in any court for or in respects to anything done or omitted in good faith in connection with the administration of or in pursuance or reliance on this subdivision or any rule, regulation, or instruction or direction issued hereunder. Ladies and gentlemen, does the Trading with the Enemies Act and Presidential Proclamation 2039 fall under this section? Most definitely. And does it not authorize you to discharge your debt? Most definitely. So you are operating in good faith. You better use this language to your advantage. You want to pay off your mortgage? Endorse that note. Bring that note. I have endorsed this bill to the United States of America, and I took the deed of trust and did the exact same thing. Since all property of the United States is owned by the United States government, it's an obligation of the United States, and I have the right to discharge it through the United States. You're going to start there. You're going to start there. We got more videos to talk about. What did I tell y'all? Did I not tell y'all that I was on my way? Huh? Did I not tell you I was on my way? Who else is going to be talking about this stuff? Okay? Who else? This right here talks about the so-called history of money. We covered that earlier. Well, guess what I did, y'all? I told y'all we were going to talk about this. The right to pay a debt using your personal credit. That's going to be the next video. Okay, and then we're going to talk about the other credit issues. But for right now, we're going to give you the information we're giving you now because you need that information. If the bank has the right to use their credit under the March 9, 1933 Act, you have the right to use your credit because you are a financial institution. Now, wait, hold on a minute. Hold on a minute. Let me put y'all on pause real quick, and I need to prove this to you. There's a lot of videos coming up. We're even going to be talking about proof of that there is a straw man. Well, this is already on our site. I'm going to be making some corrections to this. There are some things in it that need to be corrected. We're going to be adding that information that you just saw. Okay? Getting rid of some of these pictures. See, the reason why I have it this way, Oh, come on. I'm sorry. I got to put the codes in here so that I can be able to use it and not have the links on it. So I'll be taking care of that. But I'll be minimizing this. Okay. But I got to put the correct stuff in here so that I can be able to minimize it. But then we're going to talk about, because that has the case law and it has the explanation as to what's going on. Ladies and gentlemen, this is what if. It's a Marvel thing. This is all right, except for the spiritistic stupidity in some of them. Don't watch those, but the other ones are all right. Okay? I think y'all appreciate what if. Anyway, uh, the fact that you're able to discharge your debt, the fact that you're able to discharge your debt, you should be able to do so using your own personal credit. If the bank can lend their credit, you should be able to discharge debt using your credit. Your credit, we're going to talk about it. Let's go. Let's do that now. Let me already have that up. Okay? And watch this. I'm going to put it, it's going to be real simple. Okay? Watch what I'm going to put up. Y'all going to love this. Let me see if it's going to let me, because it ain't letting me do nothing. Come on now. Get on out of the way. Okay, now watch this. Personal credit should be legal tender, huh? It's accepted by Congress. Once the plaintiff's acceptance is stamped, the draft becomes money, market obligation, and is freely tradable. Wait, once the plaintiff's acceptance is stamped, the draft? I don't know. Bank of America versus the United States? No! That can't be! Bank of America is admitting that when a person does an acceptance and they stamp it, that it becomes, the draft becomes money? Wait a minute! Oh! A debt is payable in legal tender. No, don't want a debt is payable in legal tender. That's not what I'm looking for. Although the plaintiff tendered a check to purchase her vehicle, the check itself, essentially, an instrument of credit. The check itself, essentially, an instrument of credit. This is a person using, oh, they're not using an hour style money order, so we're going to have to read this. Intends to use the information connection with a credit transaction involving a consumer on whom the information is to be furnished. Although the plaintiff tendered a check to purchase her vehicle, the check itself is essentially an instrument of credit. Look at that. The check is an instrument of credit. The defendant argued that it did not violate the Fair Credit Reporting Act when it requested the plaintiff's credit report because it intended to use the information. It didn't matter. She paid you with a check. You had no business running a credit report. Okay? The payment by check or draft is common in business transactions, and the court uniformly holds that the absence of objection, a tender of either is quite as effective as though made in currency of the United States. Ladies and gentlemen, a payment in a check or a draft or in a money order or in a personal letter of credit, these are common things in the United States. Hold on. You cannot do a check or a draft. You have to comply with the law. Don't just start going out there writing checks and drafts if you don't go over the law, the Uniform Commercial Code covering that. What's wrong with you people? Section 3 and 6 of the Uniform Commercial Code. In any event, a personal check is usually regarded as tender. In any event, a personal check is usually regarded as tender. So if your personal check is regarded as tender, so is your credit. All you got to do is type it in like I did. That's what we're going to be talking about next, okay? We got another one for credit cards, so it's already up here ready for y'all. Okay? This is what I do. I said to my people, my people, if you help me, I will help you. If what I have been providing hasn't been of help to you, then you are not my people, because I'm here to help my people. Okay? Really is just that simple. I am here to help my people. I got to move all of those windows here because that's the one I'm going to use to be talking to you guys from now on. All right, ladies and gentlemen, gentlemen and ladies and gents, I want to say that it has been a good 5 hours today, focused on just 2 videos, talking to you guys, showing you the information. It is 9 o'clock, 8:54. So it's time for me to go and wind down because I've been able to accomplish things today, but I still have to proofread an arbitration so that I can get it out to the parties. I started proofreading it today, but I ran into some problems and I had to finish installing some things. So I figured while I am trying to rest my brain so that I can proofread it and make sure that all of the mistakes, and there are certain sections I'm going to pull out because I don't need to prove those points, but other sections are firm and there for a reason. The sections I'm going to pull out, I'm going to send to um, the parties separately in a addendum notation so that they can understand the points that are being relied upon. All right, ladies and gentlemen, you all take care. Thank you for letting me bring this 2 hours almost video to you, and I hope the information is beneficial. And Mariah Carey was talking about emotions before we got started, so we're going to let her finish talking about emotions. Take care of everybody. I do know everybody's been talking about how to discharge debt. If I haven't given you a start with that code, then you don't understand anything that's being said and you shouldn't be watching any of my videos. Literally. Because all of the information you need has just been given to you about discharging your debt, which is the one thing everybody keeps asking me about. You just have some studying to do, and many of you are not willing to do the study, and I'm amazed by that. All right, ladies and gentlemen, have a good day.